So this cases have had a couple twists and turns. Uh, we started out here in 4D court, and then you made a ruling back in October uh, that the state denovoed, and then the district court um, affirmed your ruling, and so we're back here. But before we denovoed it, there both parties did not have attorneys, but now they do. Um, we're Your Honor, we would like to have or they would like to have a special hearing date to basically go over the arguments again, and also there's also a new issue of the child support. Essentially, Mr. Hayden would like the child support. See, it's right now he's already, even besides the fact that child support's been abated, um, his gross monthly income is above the it's above or his net re it's above the limit, the maximum. So the state's position is that, we go for guideline. If it's anything higher than that, we'll defer to you. Mr. Hayden wants to go higher than that, especially considering it's the first of the year, so there's new numbers for Mr. Jackson's income. Um, but Mr. Williamson does not agree to that. So even besides the issue of the future pay that you granted Mr. Jackson back in October, the 18,660, and then the abatement of child support. There's also that. State understands that the parties are going to be wanting to do discovery. So the state has no objection to us having a special hearing date where they can do all that and we can get this case finalized.
All right. I was trying to see what was de novo and what was final and what may not have been final. Well, okay. But anyway,
May I go over that, Your Honor?
yes, you may. Thank you.
So in the temp order, you gave credit for a lump sum payment from Social Security.
Right.
That payment occurred before the court's order in 2020. And so that's the biggest part of our fight is, we're claiming res judicata and also statutory interpretation, all that good stuff. And the court, the state de novoed that ruling. Judge Jones said, well, since this is a temp order, it's not like you can go to the Austin Court of Appeals, so I'm just going to affirm it and let Judge Nelson take first crack at a final on this. Okay. And also, it won't be Judge Jones if we ever get back there. So that probably played a role.
You got a brand new district judge to deal with, and I need to talk to those. I need to set up a meeting because I was looking at them. I'm not. I got to double check and see is anybody's done any family law. So yeah,
he's done a lot of a fair amount of CPS work.
It would actually be in front of Judge Dusky because Judge Jones heard it because Dusky was in jury trial.
Oh, okay.
Okay.
Yeah, you're right. You're right. I remember Judge Jones took because you see there was the limit. We need to have at least try to have the de novo hearing within 30 days of the I think of our request or something. So Judge Jones took over from Judge Dusky because of that.
So this is Judge Dusky's bailiwick. All right, got it. All right, guys. So y'all want to do discovery? Okay, and that usually requires, well, somewhere between 30 and 60 days, depending on what kind of discovery everybody wants to do. If everyone wants to do their written discovery first, and then they want to set depositions after that, oh man, I haven't done that in a long, long time. So how long, I'll start with you, Mr. Hayden. How long do you think you need for discovery? And then I'll go to Mr. Williams.
Well, first I'll say, we don't even need discovery if the court rules against us, because this is all about what his child support would be were it not abated. So I'll just say that. But if we do need discovery, then probably 120 days, right? 30, 60 plus some time for depositions if need be.
Okay. Yeah. We're talking about some serious money here, so I understand. All right, Mr. Williamson. You're
Judge, I mean, I'm kind of the same. The issue that I would want discovery on would be Mr. Hayden's statement of wanting to go over the guideline cap, which right now there's no pleadings for.
He's entitled to ask for, but yeah, definitely the burden of proof falls on him. So yeah, you have the right to get discovery on all that good stuff. So yeah.
Yeah, I don't necessarily need 120 days, just enough to do the.
Well, I was looking at doing between 60 and 75. I think that probably would cover it, guys.
I think
And would y'all
75 would be.
would y'all want to do this live, or would y'all want to do this on broadcasting? Because you got a lot of if you think you're gonna have a lot of evidence to put in and things that'll be marked. I hate to make y'all come in downtown Belton, but hey, I gotta come here every day. I went to high school less than from where I'm sitting right now, so yeah, I've been coming downtown Belton a long time. So yeah.
Judge, I would say Zoom is fine as long as we have the option to move for an in-person hearing if the discovery discloses something I'm not expecting.
All right, Dan. Well, let me look at it. So we're looking at something let's say approximately 90 days out to cover everything, and that gives the 60 to 75. So I should have lots of hearings slots available on that time frame. So let me bring up the Zoom, because this thing has been acting up lately. The Zoom calendar sometimes goes blank on me. It won't show me any of my hearings. So let's see if they're there today. They're there today. They weren't there yet the other day. So anyway, let's get into sometime after my next steroid shot for my knees. So all right, here we go. Let's look at that first Monday after that. All right. All right, gentlemen, next day, I usually do my special settings on Monday afternoons, all day on Wednesdays that we don't have live docket for enforcement, and sometimes on Friday, depending on folks' schedule, when folks' schedules just demand that we do it on Friday. But for right now, I'm looking starting on the 7th of May. On the 7th of May, I've got every afternoon available on those Mondays going forward, except the Monday of the 14th, which is Comanche County's docket. So I got the 7th, 21st, and 28th available for the entire afternoon. And as far as the Wednesdays are concerned, I've got the 9th. Anytime on the 9th, I was going to set this. I was going to probably set this for a half a day docket, so a 3-hour docket, 3.5-hour day, 3.5-hour docket, just in case. I've got anytime the morning or the afternoon of the 9th, and the morning and the afternoon of the 23rd, and the morning and the afternoon of the 30th available. So you got lots of slots y'all can choose from.
All those dates are open for me. I would prefer Friday over Wednesday just because I do intakes on Wednesdays.
Okay. All right. Well, I hadn't looked at the Fridays. Let's see, but I think Fridays. I usually do Friday mornings because let's face it, at 4 o'clock on Friday afternoon, nobody's hitting on all 8 anymore, and now the Chevrolet pickups come with turbo 4s. Nobody uses 8 cylinders anymore anyway. So hardly.
Yeah, if we do Friday afternoon, you might hold me in contempt.
Yeah, because been a long week. So okay, let me double check my Fridays. Okay, Friday the 4th is available. The 11th is available. Oh, Good Friday's the 18th. So yeah,
Yeah.
Y'all kind of close that day.
Well, Judge, are you looking at 2025? Because your days of the week are not lining up with the numbers for my calendar.
April. I'm looking at April. And,
I thought we were in May.
Oh,
okay.
I'm sorry, April.
All right. All right. All right. I get that. That was.
Yeah, that's 75 days out plus. This is just
I just misheard.
Yeah. So I was looking at April. Okay, go. Yeah.
I may have been a math teacher, but that doesn't mean I know how to do it.
Exactly right, but it's got to give me the right year. So
yeah.
All right, so I got any Friday in April available, and except Good Friday, and any Friday in May is also available. And like I say, I like to start those at 9:30, and I do those 9:30 on Fridays to 12:30 on Fridays, or 1 o'clock. So, any preference, Mr. Williams?
I don't. Any of those Fridays will work, Judge.
Okay, then, well, let's get back, let me go back into April and let's put it dead center, either either the 11th or how's the 11th look for you guys?
Work.
All right, well, I'll set this up as a special setting, 9:30 a.m. We're gonna need a pre-trial before that just to make sure everybody's ready to rock and roll, or
Sure, and we can pass it if need be. It are we gonna just follow the level 2 dates, or are we gonna set specific dates for when discovery is due?
let me give us some thought right quick. This is the 7th. I like to set my own dates that way, like we can put them in the order and there's no problems. So what my normal thing is, I would want to go ahead and get all written discovery. I usually get that 10 days, so I would say all written discovery has to be out. Let me get back into January. So all written discovery would have to be submitted to the opposing, or must be out and going to the proper opposing side or other side by January the 17th, and at 5 p.m. So that puts that 30 days. So 7th of the 18th. All right, so and that means the 30 days on top of the 18th of the 18th of March. So so all written discovery would need to be sent out only before the 17th of January at 5 p.m. and all other discovery depositions, anything else like that would need to be completed only before, I'll give y'all plenty of leeway on that, only before the 31st day of March. Okay. So get the written stuff out, and then y'all can schedule anything y'all need to and get it done before the 31st day of March, and that should take care of it. And please remember, the judge is going to have a birthday in between those dates, and I'm going to be more cantankerous after my birthday. So
No.
well, you get I love that term, cantankerous. Okay. So. All right, is there anything else, gentlemen? Like I said, I'm getting ready to make that Zoom code, and does anybody have a question? Is there anything else we need to do? And I usually do the pre-trial the week before the hearing. So if we're doing the hearing in April like that, let's see. Let me get back to April.
So
my general Zoom, I got a general docket.
The April 11th one?
Yes.
All right.
As soon as we get through here, I'm gonna go ahead and get that Zoom code, and I'll send it out to Ms. Walker and Linda, and y'all should have it within the next 15, 20. Well, they'll have it within the next 15 to 20 minutes. Y'all will get it when they're darn good and ready to send it to you. Okay.
Judge, I do have a matter I would hope to get addressed today.
And what's that?
So in the temporary order, the court abated current child support. And I would ask that the court temporarily reinstate that child support. I work for legal aid, so Miss Seals is not exactly rolling in dough.
Right.
And it hurts that she's without.
Mr. Hayden, I would need a motion on that to give everybody notice that that's what was there a motion on that for today?
Well, honestly, Judge,
I want to ambush the state or Mr. Williamson on that issue. I'll set it up for a further quick temporary hearing if y'all want to, but again, I haven't looked at that, and I'm of the point that I normally I don't like changing temporary orders if I already ruled one way. So I would give you the opportunity to make your argument, sir. But again, I'm not sure if that's appropriate for the day.
Okay, I thought today was going to be a final hearing when I showed up. So with that in mind, I would like the quickest possible setting to get that issue heard.
All right. Well, I'll let you. I'll tell you what. File the motion, and let everybody be able to read it and get their defenses ready one way or the other. Again, you're asking for the mod, so I'll put the burden of proof always on the person who's requested this, and. I got 31st at 12:30, 1 o'clock. Like I say, it's just a motion, so it should take less than an hour no matter what. And I'm available on that afternoon. How about you guys?
I can do that.
Did you say January 31st?
Yes, sir.
Yes, I'm available.
All right, I'm gonna make a separate Zoom code for that, along with the separate Zoom code for the final hearing on this matter. In fact, if Zoom will let me tweak it, it may end up being the same Zoom code for both, but you will get a special setting Zoom code for the 31st at 12:30 p.m. please. All right.
Thank you, Judge.
All right. Anyway, thank y'all all very much. Apologize for making y'all wait so long. And is there anything else?
It's all, Judge.
I just want to make sure I got it all because we've said a lot. So
Oh yeah, and I wrote some of it down. So there you go.
So on January 31st, 2025, we're going to have a separate Zoom code for a temporary hearing on child support.
Well, Mr. Hayden's motions, yeah, one spot.
Yeah, all right. And then April 1st, we'll have our pre-trial at 9 a.m. general Zoom docket. And then on April 11th is when we'll have the final hearing at 9:30, and it'll be a special Zoom code.
Yes, sir. Yes, ma'am. All right, that's pretty much it. Judge used to always like doing divorces on April Fools Day. People seem to enjoy that. Once that lady cried because I was trying to do a divorce on Valentine's Day, and she didn't want me to ruin it for the rest of her life. So I fled, and we moved it to April Fool's Day, and she thought that was just funny as I'll get out, and we went with that going forward. So yeah,
that's pretty good.
All right, everybody. I'll see everybody on that date. Now come heck of high water. If it turns out to be a snow day, I'll run it from the house and we'll get it done. All right.
Yes, sir.
Thank you, Judge.
Right,
Thank you, Jan.
Thank you,
Have a
Jan.
good one.
They're not sure what Thursday and Friday is going to be, but yeah, everybody be careful. All right. Thank you.
Yes, sir.
Thank you, Your Honor. I'm working on the receipt order, Your Honor. Can I ask them to stay in the breakout room while we get that taken care of?
No problem. Okay. If somebody's got to leave, they got to leave. But for right now, let's see if y'all go back to the room and hang around just.
Yeah, can our clients be dismissed? I don't think they need to stick around for that.
Okay. Yeah, I wouldn't see why. So.
All right.
Thank you.
Y'all have a good one. Thank you.
Bye, Miss Seals.
Thank you, sir.
Goodbye.
Thank you, Your Honor.
Seals, Mr. Jackson, have a good one now. Thank you.
You too, sir.